Allow me to introduce you to William Wirt. He was Attorney General for more than 11 years back in the 1820s under Presidents James Monroe and John Quincy Adams. He's the longest-serving Attorney General in U.S. history. The next longest-serving AG was Janet Reno, more than 150 years after William Wirt. She got closer than anyone else in history to his record when she served nearly 8 years under President Bill Clinton. So what about the guy who's there now? What about Eric Holder? At the start of President Obama's second term, a lot of the other really high-profile members of the president's cabinet left. Not necessarily because of the scandal or disagreement with the president or something, but because, you know, first term's up, time to move on. Hillary Clinton left as Secretary of State. Tim Geithner left as Treasury Secretary. Stephen Chu left as Energy Secretary. All the marquee names left, but not Attorney General Eric Holder. He stayed with sort of quiet assurances at the time that he did not intend to stay for the whole second term, but he did want to stay at least a little while longer. So he is still there now, 5 years into it and counting. And nobody's quite sure exactly how much longer Attorney General Eric Holder is planning to stay in office. While he's still around, though, turns out he's making it crystal clear that he's going to make the most of the time that he has left. The Attorney General, sort of quietly, without much attention, has been on a real tear recently. I mean, at a remarkable pace, he has made big policy announcements and policy changes and some pretty dramatic statements about public policy and fights that he wants the Justice Department to engage in, all from his perch atop that department. This latest example was this week, a speech at Georgetown University where he put a spotlight on the fact that there are 5.8 million people in this country who aren't allowed to vote, even though they are adults and they're legal American citizens. The Attorney General described it as unjust and unacceptable. 5.8 million people, larger than the population of 31 individual states. 5.8 million people is the number of Americans who would otherwise be able to vote, but who can't because they have a criminal record. 11 states continue to place restrictions on people's right to vote even after they've served their time or finished off their probation or parole, after they've fully paid their debt to society. In Florida, that means that fully 10% of the population that would otherwise be able to vote can't vote. 10%. In Mississippi, it's 8%. This week, Attorney General Eric Holder called for all states to reform those policies. And to make the point that this isn't and shouldn't be seen as a partisan issue, Mr. Holder cited Republican Senator Rand Paul's work on this same issue. He also cited Republican former Virginia Governor Bob McDonnell's work on this issue. Although now that Governor McDonnell is facing a federal criminal indictment, maybe now we should see that as a slightly more self-interested decision than it seemed like at the time. Still, though, point made. And Eric Holder really has been on a tear. Before this week's clarion call on voting rights, the Attorney General has taken on stand your ground laws across the country. He sued Texas over its voter ID laws. He called for the end of mandatory minimum sentencing policies for nonviolent drug offenses. He cleared the way, when he didn't have to, for Colorado and Washington to go ahead with their new state laws that legalize pot, which meant some major changes to DOJ's priorities when it comes to prosecuting marijuana cases. He also announced that same-sex couples who were married in Utah before the state shut down their right to do so, Eric Holder announced that those couples' marriages would be recognized by the federal government even if they weren't recognized by their home state. He also issued new policies that eliminate the distinction between married straight couples and married gay couples in federal criminal justice matters, stuff like filing for bankruptcy, the rules about testifying against your spouse in court, all that stuff. And those are not all the things he's done this year, but he has done all of those things this year, just in the past year since he and President Obama started their second terms in office. Again, nobody knew heading into the second term whether or not Attorney General Eric Holder even wanted to still be in that job. But the way he has spent this past year, sort of quietly, makes it clear that he is making the most of it. And along the way, seems to be becoming one of the most quietly consequential attorneys general ever. Meanwhile, though, at the same time, there's a revolution happening in the federal courts on the gay rights issue that Mr. Holder has made such a high-profile part of his time in office. On Wednesday night this week, a federal judge in Kentucky ruled that that state has to recognize same-sex marriages legally performed in other states. That follows a ruling in the even more conservative state of Oklahoma last month, striking down the Oklahoma marriage ban. The Oklahoma decision followed a similar federal court ruling in Utah, striking down the Utah marriage ban. Just this week, the Republican governor of Nevada said that neither he nor the state's Democratic attorney general will defend that state's marriage ban as it is challenged in federal court. And now it's Valentine's Day. And about 90 minutes before midnight, at about 10:30 p.m. Eastern last night, a federal judge in Virginia handed down her own impassioned ruling, striking down the Virginia ban on same-sex marriage. Coincidentally or not, timing it so it would be in every Valentine's Day newspaper in the country this morning. The ruling starts with a quote from Mildred Loving, from the famous Loving versus Virginia case that struck down that state's ban on interracial marriage. And it ends with a ringing and unequivocal striking down of Virginia's same-sex marriage ban today. With all this happening at the federal level, both in terms of policy from this apparently newly energized Justice Department and from the courts at rather lightning speed, what's going to happen next year? Joining us now is Kenji Yoshino. He's the Chief Justice Earl Warren Professor of Constitutional Law at NYU. Kenji, it's nice to see you. Thanks for being here.
Great to see you, Rachel.
So we have seen this sort of cascade of similar rulings in other states recently since last summer's landmark rulings. But this one in Virginia sort of feels like it has a little more, at least, historical heft. Am I right, or am I imagining that?
No, I think you're absolutely right. In fact, when I asked Ted Olson, who joined this case, he, of course, was part of the odd couple team that litigated the Prop 8 case in California. I asked him, why this case? You could have had your pick of cases. Everyone was inviting you into these cases. There are, dozens of them now percolating around the country. Why Virginia? And he said, well, it's because I spent my formative years in California. I currently spend a lot of time in Virginia, and so these feel like homes to me. But it's also because of this Loving versus Virginia case and the salience that Loving versus Virginia has in our constitutional history. So if you think back to 1967, a unanimous Supreme Court, Chief Justice Earl Warren, writing the opinion, strikes down this ban on interracial marriage, saying that it is now the law of the land that individuals can marry whoever they want, regardless of race. And so he said that the poignancy of joining a case in Virginia and drawing the analogy between the interracial marriage issue and the same-sex marriage issue was what drew him into the case.
The Virginia decision does echo what we've seen elsewhere in citing the Windsor case to invalidate this state-level ban. Is it starting to feel to you like that's just the logical and, in fact, predictable outcome of that decision every time federal judges are going to look at it now around the country? Could things have gone the other way on this case?
They really could have. And I think that if you look at Justice Scalia's dissent in the Windsor opinion, which was the 2013 opinion handed down just last summer, he called the majority opinion's reasoning shiftless or rootless and shifting, I think, were the terms that he used. And so what he meant was that it was kind of up in the air as to whether or not this was a state's power decision or whether it was a gay rights decision. Because if you interpret it as the problem with the Federal Defense of Marriage Act was that it failed to recognize marriages for federal purposes that the states themselves had recognized, that would be a state's powers issue, because marriage has traditionally been, as all family law is, a matter of state law, just as a presumptive matter. So if that had been the ground of the ruling, that wouldn't really have had that much effect on these state bans, because if it's a state prerogative to define marriage, they can define it howsoever they will. On the other hand, if you read it as a gay rights decision, that means that these same-sex restrictions on same-sex marriage, these bans on same-sex marriage, are just as obnoxious to the Constitution as the federal denial of benefits was. And so of these two interpretations, we didn't know which one would prevail. And so it was really left to the lower courts to kind of suss it out. And now we have Utah and Oklahoma and Virginia, not necessarily predictable jurisdictions, saying Windsor was a gay rights case, and there's no other way to read it. And so now the decisions are piling up and accumulating in a way that I think is very, very powerful in terms of how this case is going to be teed up for the ultimate decision by the United States Supreme Court when it returns there.
Exactly. And that's the fascinating thing to watch now, is not just what's going to happen in these individual cases, but which one of them ends up being the basis on which the Supreme Court makes its next decision. Fascinating stuff. Kenji Yoshino, NYU Law, thank you very much for being with us. Kenji, appreciate it.
Thanks so much, Rachel. Happy Valentine's Day.
You too. Thank you. Stay with us.